The case of the people of the Philippines versus Rufino Umanito is a rape case where the appellant Rufino Umanito was accused of raping a woman referred to as AAA in the case documents. The case represents several conflicting assertions from the both prosecution and the defense, with the most significant point of contention being the nature of the relationship between the appellant and the victim. The case is particularly notable because it brought up the use of DNA testing as a means of determining the paternity of the child. Born as a result of the alleged rape, the court acknowledged the potential of DNA testing to provide new relevant information for the case. Those ordered a DNA test to be conducted. The court asserted that is the DNA test conclusively determined the accused was not the father of the child. It would cast a reasonable doubt on his guilt and could potentially lead to his acquittal.
In this case, we remanded the case to the RTC for reception of DNA evidence in accordance with the terms of said resolution. And in the light of the fact that the impending exercise will be the first application of the procedure, directed Deputy Court Administrator Reverend de la Cruz monitor the manner in which the court carries out the DNA rules and assess and submit periodic reports of the implementation of DNA rules in the case to the court. To recall, the instance case involved a charge of rape. The accused, Rufino Umanito, was found by the Regional Trial Court of Buang La Union, Branch 67, guilty beyond reasonable doubt of a crime of rape. Umanito was sentenced to suffer the penalty of reclusion perpetua. In order to identify the private complainant in the sum of 50,000 on appeal, the Court of Appeal offered the judgment of the trial court. Umanito appealed the decision of the appellate court to this court.
Umanito said that he courted the victim. However, the victim rejected him. Also, the victim frequently visited the house of Umanito because he said that the victim has a crush on him. Furthermore, the testimony of the victim is inconsistent about the nature of the relationship. The first statement that the victim said is that he only met Umanito on the day she was raped. Second, she said that they are friends. Later, she also said that they were close friends. That's why their statements contradict each other. Aside from that, Umanito said that he was just in their house helping his parents to work with the picture frame that was ordered from Baguio. Therefore, this is where the DNA test was used because the victim got pregnant. To determine if the victim was raped and if Umanito was the father, they used DNA test to determine if it is true. Furthermore, they used the buccal test in both child and Umanito to determine if he was really the father. If ever he was not the father of the child, his acquittal will be ordained.
Umanito later filed a motion to withdraw his appeal, which was granted. By filing such motion, Umanito is deemed to have acceded to the rulings of the RTC, and the Court of Appeals finding him guilty of the crime of rape and sentencing him to suffer the penalty of reclusion perpetua and indemnification of the private complaint in the sum of 50,000 pesos. The decision of the court was based only on the complainant's testimony, but also the result of the DNA analysis conducted by the National Bureau of Investigation Forensic Division.
It was around 9 o'clock in the evening of July 15, 1989, while on her way to her grandmother's home when private complainant AAA was accosted by a young man. It was only later later when she learned that the name of accused appellant Umanito. She recounted that accused appellant Umanito waited for her by the creek and then, with a knife pointed at AA's left side of the abdomen, he forced her to give into his kisses, to his holding her breast and stomach, and to his pulling by her by the arm to be dragged to the home economics building inside the premises of the Daramuangan Elementary School, where accused appellant Umanito first addressed her, which is the private complainant, and himself with his right hand while he still clutched the knife menacingly on his left hand. Private complainant AAA recounted that she could not shout because she was afraid. She further recounted that accused appellant Umanito laid her down on a bench 4 meters long and 24 inches wide, set the knife down, then mounted her, inserting his penis into her AA's vagina, and shortly thereafter accused appellant Umanito dressed up and threatened AAA while poking the knife at her neck not to report the incident to the police or else he said he would kill her. Accused appellant Umanito then left. While the victim AAA went on to her grandmother's house, she noticed that it was already around 1 o'clock in the morning when she reached there. In 1990, 6 months after the incident, private complainant AAA's mother noticed that the prominence on AAA's stomach. It was only then when the victim private complainant AAA divulged to her mother the alleged rape and told her the details of what had happened on July 1989. After hearing private complainant AAA's story, her mother brought her to the police station. And then, according to the accused, he denied the accusation of AAA. He claimed that on July 15, 1989, he was home the whole day, helping his family complete rush work of picture frames ordered from Baguio. He did not step out of their house on the evening in question. He added, concerning his relationship with AAA, appellant admitted that he had courted her but she spurned him. He conjectured, though, that AAA had a crush on him since she frequently visited him at his house. It was only 5 years later that the appellant was arrested. It took place when he went to the municipal hall of Naguilian to secure a police clearance, and then on arraignment, he pleaded not guilty. RTC rendered judgment against Umanito and sentenced him to suffer reclusion perpetua. Umanito's appeal was transferred to the Court of Appeal to intermediate review, and Court of Appeal affirmed. Umanito seeks acquittal on reasonable doubt with the belated filing of the case and AAA's questionable credibility as ground, given that there were several inconsistencies in her assertions.
DNA testing is to ascertain whether an association exists between the evidence sample and the reference sample. Through DNA testing, this case may determine whether the prosecution met the level of proof needed to find the appellant guilty of the crime or the acquittal of this case. Take note that the applicability of DNA evidence does not adopt a specific rule on admissibility of the DNA evidence. General rules on relevancy and not excluded by law or rules are only requirements, matters not specifically covered by the rules of court or the rules of evidence, which stated in Rule 128, Section number 3, the admissibility of the evidence, that the evidence is admissible when it is relevant to the issue and it is not included by the law of these rules. By the amendment matters number 06-11-5 of the Supreme Court, which took effect on October 15, 2007, the court recognized and approved the use of DNA evidence in this case. In the case of Rufino Umanito, the fact that AAA bore a child as a result of the purported rape, with the advance in genetics and ability of the new technology, it can now be determined with a reasonable certainty whether appellant is the father of AA childs. If he is not, his acquittal may be ordained. Therefore, the DNA samples were thus extracted from AAA and BBB in the presence of Judge Peck, the prosecutor, the counsel for the defense, and BCA de la Cruz. On February 8, 2008, DNA samples were extracted from Umanito at the New Bilibid prison by the NBI chemist Aranyas, as witnessed by Judge Fe, the prosecutor, and the defense counsel, DCA de la Cruz, and other personnel of the court and the New Bilibid prisons. To ensure the reliable result, the standard operating procedure of Forensic Chemistry Division of the NBI in paternity case is to use buccal swab taken from the parties and blood as a backup source. In the analysis of the 16 loci by the forensic chemist, a male on the 13th row was not excluded because this is the marker that determines the gender of the source of the loci. For matching paternity purposes, only 15 loci were examined. Of the 15 loci, there was a complete match between the alleles of the loci of BBB and Rufino Umanito. At the hearing, Provincial Prosecutor Maria Ninita A. Opinia presented Mary Ann T. Aranyas, a forensic chemist of the National Bureau of Investigation, who testified on the examination she conducted, outlining the procedure she adopted and the result thereof. She further declared that using the PowerPlex 16 system, the observable-lactic acid analysis on the buccal swabs and the blood stain on FTA paper taken from AAA and BBB and Rufino Umanito E. Milares to determine whether or not Umanito E. Milares is the biological father of BBB, showed that there is a complete match in all of the 15 loci tested between the alleles of Rufino Umanito E. Milares and BBB. That based on the above findings, there is a 99.9% probability of paternity that Rufino Umanito E. Milares is the biological father of BBB. That considering that under Section 9 Amendment Matter number 06-11-5 of the Supreme Court, if the value of the probability of paternity is 99.9 or higher, there shall be a disputable presumption of paternity. The instant case was set for reception of evidence for the accused on April 29, 2008 to controvert the presumption that he is the biological father of BBB. Therefore, the findings and remarks of this DNA analysis led the court to meet the probability of paternity and also successfully met the level of proof needed to find appellant guilty of the crime of rape.
Because of the insufficient testimonies that Umanito presented in the RTC, the prosecutor had proven appellants guilty beyond reasonable doubt. The RTC rendered judgment against him and sentenced him to suffer the penalty of reclusion perpetua and to identify AAA in the sum of 50,000 pesos. In so doing, the court held that the discrepancies in AA testimony did not impair her credibility. Despite some inconsistencies in her statement, the RTC observed that AAA's demeanor on the witness stand did not indicate any falsehood in her narration. The defendant is not satisfied with the ruling of the lower court. He filed an appeal in the Court of Appeals, but due to some review conducted and with the presence of the DNA that has been taken from the defendant, the complainant, and their child, the said court affirmed the decision of the lower court, and the defendant has been guilty beyond reasonable doubt. So ordered.